before we start, I'll just give a little introduction about myself. So I'm Akanksha and I am a senior data protection consultant with Tsaaro. And I am also a privacy professional certified by the IEPP. I've cleared the CIPP exam. That was a little about me. Moving on to the subject matter, we'll start off with what all role-based management people are involved in management of the data protection or the by as per the GDPR, and we'll also look at what are the compliance requirements set up by the same. So starting off, we're looking at who a data controller is. So as it was already said by Divyansh, that the law came in, the regulation came in, and it set out a different set of rules for different organizations to look at. But again, it also divided the roles and the responsibilities and the obligations in terms of who's going to do what. So when we talk about the management of the data protection, we are looking at the procedure and the processes that are to be for the management of the resources and the activities that are embedded in the data protection regulation. So if we look at who a data controller is, by the definition of it, we can say a data controller can be an individual, a legal person, or it can also be an organization. So when I'm saying, like, I totally understand that a lot of legal professionals are also there. So I would modify my definition a little bit. So it can be a legal person, a natural person, a public authority, or an agency. So if we say a public authority and agency, so it can also be a joint body of several of these say entities that I've mentioned, and then they can go on to be the data controller as well. So if we talk about role of the data controller, so what exactly a data controller does? So a data controller goes on to determine that for which particular purpose and for how the data will be processed in the data processing activity that we are looking at. So the role is basically that why and how the data processing will be taken up, and who's gonna be assisting the data controller will also be something in the hands of the data controller to decide. So if we look at if there is any qualification for somebody to be a data controller, there is no limitation as such for one to be a data controller. But again, if we look at it, there can't be a situation or a scenario where an individual person is a data controller or he's acting as a data controller. If we're talking about individuals, they can definitely go on to act as agents of data controllers, but no individual person can ever be a data controller. So we are also looking at a situation, say if the purpose of the processing activity is determined by union or local laws, then the data controller would be then nominated by that particular union law itself. That could be a scenario wherein this person who's deciding who can be the data controller, that responsibility is vested with the government of that particular region. If we're looking at a second scenario, if we're looking at, say, the unincorporated organizations or say groups, if we take the example of, say, a sports club, and in the processing activity or in fulfilling the purpose of their being, if they are going on to process any personal information or they are taking up any personal information, then who can be the governing person or who can act as a data controller? So for authorities or organizations as such, there wouldn't be a person who will be looking at it, but it is the obligation or the responsibility of it is vested with the managing people or the members of such groups. So again, if we look at who can be a data controller, I'll help you with an example here. So if, say, we are going to a multi-specialty clinic, if we're going there and we have our registration done and we're sitting in a lounge wherein there is a screen placed in the walls of it, and then we are waiting for our turn to come in. So as and when our turn comes in, we see that our name or the patient's name is mentioned on the screen, and also which particular room number that patient has to go to. And it also mentions the specific department or which kind of doctor are you gonna go and meet. So if such information is being flashed on the screen by automated means, then we can go on to say that the office of the clinic or the office of the doctor that we're going to, they are responsible for the same, and they can also go on to act as data controllers. So that was a little on who can be a data controller, a little on the definition of it. If we go back to the regulation and the definition clause under Article 4.7, the data controller has been defined, and that was a little about it. So we now know that the sole person responsible for the decision-making part on the processing of such data would be the data controller. Moving on, we'll look at who will be a data processor. Right. So as I defined, I went on to define who can act as a data controller. Similarly, for a data processor also, a data processor can be a natural or a legal person. They can be a public authority, an agency, or it could be multiple entities or authorities joining in to be joint processors as well. So as I mentioned, and I gave an example of, say, the nomination of the controller by the union or the state laws. Similarly, if we are looking at an activity that is being performed, then this data processor can also go on to be an entity which is nominated by the union or the state laws. So the only difference that we here looking at in terms of comparison between who a data controller and a data processor is, it is on the roles that they go on to perform. So if we look at the role, say when we mentioned that data controller goes on to decide how and when the processing activity will be conducted, then for the data processor, we can say that the data processor goes on to act on the behalf of the data controller, and they are usually a third party or an external which goes on to assist the data controllers in the processing activity they are performing. Talking about the qualification, if we look at it, there is again no limitation on who can be a data processor. But again, if you're talking about the legal obligations, they do not really have similar legal obligations as a data controller, as we can go on to say the controller is the master of the processing activity, and the processor is a person who is assisting him in the whole process of it. So if we look at what obligations or what functions a data processor goes on to perform, we can say that data processor has that independence to decide onto the operational aspects of the processing activity that is being conducted, but he'll have to make sure that he only goes on to perform or do the needful in only at the instructions of the data controller that is there. So if we look at the exceptions where a data processor can go beyond the instructions of a data controller, we can say where a situation arises where the data processor is directly instructed by the government authorities to perform the activity, then he can go beyond the instructions of a data controller. So if we can look at that, if a data processor is a person who's only acting on the behalf of the data controller, we can also think that, okay, the employees of a certain organization are also data processors who are working on the behalf of the data controller. So if I am associated with Tsaaro, and I am going on to perform any functions or undertaking any activities, I can also be a data processor for Tsaaro or not. So that is untrue. I cannot be a data processor, but in turn, I can be, say, if Tsaaro is the data controller, I can go on to be the agent of the data controller as well. So looking at the obligations again for the data processors, so we can look at, say, two scenarios wherein the data subjects go on to complain about any issues that they are facing with the processing activities. So if a data subject is going on to a statutory authority for any complaints or any issues that they're facing, they can take up the complaint against both the controller and the processor at the same time. There could be a scenario, as I already talked of, that if the processor goes beyond the instructions of the data controller as well, so that could be a breach of the instructions that are given by the data controller, or a breach of the contract between the controller and the processor, and then the processor can be fined heavily for the same. So if just to summarize what all activities or what all responsibilities are vested with the data processor, we can say that they are to assist the data controller. They are to look at the implementation of technical and organizational measures. We usually call them the TOMs, and they are also vested with the responsibility of the security and the maintenance of all the data subject rights that are vested with the data subjects. So if a data controller is obligated to look at certain data subject rights, the data processor will certainly have to assist the data controller in fulfilling those rights as well. So that was a little about the data processors. Moving on, we will be talking about the records and the security of processing. So as we already know, the GDPR obligates there should be a written sort of documentation so that if therein comes a situation where one needs to have an investigation on what sort of processing activity and how it is being conducted, that particular written documentation can be looked at and an overview of the procedure can be taken up. This primarily helps in the process or an event where audit is happening, and that is how the ROPA or the records of processing activities help us in the process. So if we talk about the ROPA, as we call it usually, so that necessarily needs to have information about the data processing, also information on the data categories, the data subjects, what is the purpose of processing, and also who are the data recipients. So if, as we talked of data processors, they can go on to act as the data recipients, as mentioned on your screens as well. So moving on, the ROPA must be completely made available upon the request of the authorities or the statutory authorities. So if we look at a scenario or a situation wherein there is an investigation that is happening, and if a data subject goes on to complain about my processing activities, then I will be obligated as both data controller and data processor to give out those records to prove that, okay, this is not the issue, and I am very fair with the processing activity that I am taking up. Next would be the obligation on, like, if we say who is that particular entity who is responsible to maintain the records of processing activities and also the security of the processing that if I am a controller and my data processor should undertake, then the answer to it would be that it is responsibility of both the entities, the controllers and the processors, to maintain the records and also the security of processing. I mean, there is a very like, this is very confusing as a factor that when we discuss about that controller is solely responsible for everything going around the processing activity. There is a misconception that for records and security of processing also, the controller is the sole person responsible, but that is untrue. The data processor is equally responsible for both of these. Moving on. So if we're looking at exemptions to records and security of processing, there could be 3 or 2, if we say, exemptions. So first being the number of employees that particular uh, entity or organization has, which is taking up the processing activities. So if we say a company has a employee size or employee base lesser than 250 employees, then they will fall under the category of exemptions. Second would be if we see or if an organization goes on to say that they do not go on to process any special categories of data, then they can be exempted from the same. But if we see that there is an occasional processing of data or special categories of data, then controller and the processor both will have to show in their records that the occasional processing activity is not like it's not a big activity that is taken up, and the sole responsibility, the responsibility to showcase or to give the evidence of it solely is vested with the data controller and the processor both. So if we are taking the exemption of say occasional processing, then we as data controller and processor should be very careful of the same. So the next thing that we would be talking about here would be of the data protection officer. So as privacy professionals, this is something, I mean, a lot of us aspire to be data protection officers for various organizations. I mean, it can be like untrue for a lot of us also, but again, this is the, something that we're looking at. And if we talk of the responsibilities of the data protection officers, so who can be a data protection officer then? So there is no qualification criteria as such that who can be a DPO, but we have very many functions in the responsibilities that are enshrined in the regulation that we're looking at. And according to it, a DPO should be an independent body, uh, a body which is responsible for investigations in matters wherein the privacy and the security aspects that are taken up in the processing activities are in question. So if one organization who can be both a data controller and a processor, if they are, say, having an office of DPO, or if they are onboarding a DPO, they should make sure that a DPO is involved in all the activities wherein the processing of personal data is being involved. Secondly, the DPO or the office of DPO must necessarily have access to all the processing activities, the operational activities wherein privacy is being looked at. Then if we talk about consumer facing controllers and processors, we can say for them, the DPO should also be responsible to look at the rights and the responsibilities one organization has with its consumer base or the data subjects. The next thing would be a DPO is strictly bound by confidentiality, because as we already know, it is one of the major factors and principles of GDPR, wherein we talk of confidentiality. And if DPO is the one person who's looking at all the aspects of it, confidentiality is one thing that he should definitely want to maintain. Then if we look at the next thing, it would be that the office of DPO or the DPO, there shouldn't be a conflict of interest for such a person, so as to it does not go on to shadow any of the integrity part or the confidentiality part that the activities of a DPO are taken up. So moving on, that was something about who a data protection officer can be and what are the activities or functions of a office of DPO for each organization, be it a data controller or a data processor. So if we go on to summarize what are the roles and the responsibilities of a DPO under GDPR, then we can say DPO is also responsible for the training of employees and also the GDPR compliance in any organization. So we look at a scenario wherein the office of DPO is conducting awareness drives and training of the employees so as to embed privacy among or in all the departments in an organization. I totally understand that it is a responsibility of the office of DPO to take care of the GDPR compliance. But again, if all people from all the departments come in and take a responsibility from their end, then we can say while the processing activity is undertaken, the privacy aspect will also be taken care of. And then the job of the DPO will be easier to do. Next thing would be conducting regular assessments and audits. So as I mentioned about the ROPAs and maintaining the security of the processing activity, similarly, an audit or an assessment on the same should be the responsibility of the DPO to be conducted. In terms of assessments, if we talk about, so he's also responsible to take up various DPIs. We're also running short of time, so I'll just take it up quickly. The DPO can also be the point of contact between company, the statutory authority, and also the data subjects, if we say. For data subjects, he should also look at the complaints that come in from the consumer base and also maintain all the ROPAs and the records of processing activities, as we've already discussed under Article 30. So who can be a statutory authority, supervisory authority, if we look at? So they can be an independent public authority, if so to say, and from any of the member state of the EU. The role for it would be for the monitoring if or not the application of GDPR, or if GDPR compliance is being maintained well, very well or not. Moving on, if we talk of powers of the supervisory authority, we can say that they have been vested with investigative, corrective, and power of authority, so as to go on to impose fines if we see that any issue is being raised by a data subject for, say, wrongdoings of any of the data controller or the processor. Also, there is an obligation factor vested with the controller that if any breach, personal data breach happens, then they are obligated to notify within 72 hours of becoming aware of such a breach. And also with the supervisory authorities, the data subjects have the right to lodge a complaint or address any issue if they're facing with both the authorities of controller and processor. Looking at the other powers, we also can say the supervisory authority is vested with a judicial remedy. And if they are seeing that if any rights are being infringed, then they can want to address the same. They can also like press on the factor that all the controllers and the processor, primarily the controllers, have this obligation to inform the data subjects that if any issue occurs, then they can go on to complaint with the supervisory authority. Then the last factor would be that the EDPB, which is the board which ensures that there should be GDPR compliance, they need to cooperate with the same. So looking at the third party transfers, so when we are saying that a data controller and a processor comes together for any processing activity, then we can say that there can be a data transfer to a third entity as well. So if any third party is being involved in the processing activity, then it is an obligation to maintain the security of the data at the same time. I believe in interest of time, I'll move forward from here. Looking at the data transfer mechanisms, so I would say there are three prevalent data transfer mechanisms to look at. First would be the BCR, second would be the standard contractual clauses, and the last ones would be the derogations. So if we look at the BCRs and the SCCs, so we can say that BCRs are a set of rules, or they are a code of conduct that are already defined by the statutory authority for, say, if we're looking at the territorial region, for the data controllers, the processes to apply with, there are certain piece of or a set of rules of code of conduct that we're looking at, and for that, if any transfer is being taken place, then they need to comply with the BCR as well. Talking of the SCCs, when any data processing agreement is being made between, say, the data controllers or the data processors, they can also be an added clause can be there, which can talk of the SCCs, and then they can look at all the technical organizational measures that are to be taken up by the data processor before such a data transfer can happen. So so to summarize, if we look at the BCRs and the SCCs together, I mean, we totally understand that the BCRs are already taken up code of conduct, or all set of rules that have already been taken up even before the such a transfer is being looked at. But for SCCs, they are tailor-made clauses for each transfer that is going to happen. So we can say, if we're looking at a contract that is happening, so SCCs can be looked at as a contract between two or more parties, and BCRs can be looked at as common code of conduct that has been sanctioned by the supervisory authority. That is one major difference between the two. The purpose that is being resolved is to look at if adequate protection is aligned to the data transfer that is happening or not. So if we look at any requirements for both of these activities to be conducted, yes, there is a requirement of licensing from the supervisory authority for the binding corporate rules, but no such licensing is required for the standard contractual clauses. So if we look at if SCCs have been aligned to the data processing agreement and the binding corporate rules are there for any transfer to happen, so who is responsible for the vestment of rights, and what all rights do parties have? So for the SCCs, there are people who are involved in the contract. They can invest, they can talk of their individual rights here, wherein the BCR's individual rights cannot be looked at, and they are just certain legally binding rules. Then if we look at SCCs, they are tailor-made to one specific solution that we're looking at. Say, if I am sitting in the European region and I want to transfer my data to, say, India, then for that specific transfer that is happening from organization A to organization B, then the standard contractual clause will talk of those pointers only, which are the requirement of, say, enterprise B to take up, so as to maintain the adequacy of security when the data transfer is being happening. But for BCR, they have already been there are certain rules that have been already made, and they are not looking at the individual agreements happening between the two enterprises. So that was something on difference between the two. Okay, looking at the derogations. So derogations are commonly called as the last resort for any data transfer that is happening. So if we look at when can derogations for a specific situation can happen or a specific data transfer is taking place. So there are certain pointers to highlight. If the data subject has explicitly consented to such a transfer, then derogations can be taken up. And if there is a transfer which is happening so as to act or give the performance on a pre-existing contract that is there, which is between the data subjects and the controllers, then derogations can be looked at. Then another thing would be that if the transfer is necessary for the vital interest or the public interest of the data subjects, or to address the issues of the public at large, then derogations can be looked at. And if they are to address any say legal issues between establishments or enterprises, then they can be taken up. Or as we already discussed, that the union or the state members have they have a higher position in taking a decision. So if the transfer is to look at such a decision by the union or the member state, then derogations can be looked at. So that was a little about the prevalent data transfer mechanisms, and that is taken up the last segment of the second session of this masterclass as well. So I would request all of you to take this code up from the screen, scan it on your mobile phones maybe, and take up the quiz so as to help us determine the participation in the quiz, and also look at who all attended the session. I believe we're already 4 minutes past the time, so let's just quickly take up this, and then we'll move on to the next session, which is based on the ISO 27001 and 27701. I believe everyone must have scanned the code by now, and I'm hopeful that it was a good session and a good learning experience for all of you. And I totally understand, for India time, people must be rushing to their offices because this is the office hour. But again, you can definitely come back to the session, because we will be helping you with the recording of the same at the at the end of the day, or maybe in a week or so. So you can definitely go and have a look at the same. Now I'll give the cue to the next presenter or the next speaker, which is Nithi, and she's going to take up the session for ISO. Thank you so much.